Okay, this is Contracts 2. You have the syllabus that's online. It's on the Twin site. It's graded the exact same way as last semester. 20% on your class participation, 40% on your midterm, 40% on your final. For those who have questions about class participation, when I call on you and you're ready, you get full credit. When I call on you and you're not ready, you don't get credit. I take the number of times you've been called on. You get full credit for the ones you were ready, no credit for the ones you weren't, and that's an average. That's your 20% is whatever your average is. Whatever's on your midterm is 40% of your grade. Whatever's on your final is 40% of your grade. The exact same way as last time. So if I call on you and you're not ready, you know that you just took a 20-point ding, unless we can get you called on again, and then you can get half of that back because that's 50% instead of 0. Anybody got any questions on that? I had so many emails asking me about class participation. It's simple. If you were called on and you answered and briefed the case, then you got credit. And that one in-class assignment, how you scored on it, also went into your average. Midterm is on February 16th. Expect it to be at least one essay and more of these multiple choice questions that are in multi-state format. In other words, 2 answers can be right. You got to pick which one's the better one. 3 answers can be right. You got to pick the best one. That's the only way you're going to learn them, is if you have those type of questions in here, so that you can answer those type of questions in 3 years, 4 years, however long it takes you to take the bar exam. Commercial study guides are really good. If you haven't gotten them, I like the Black Letter series. Convisor, I think, is one of the old ones. Your commercial outlines about what you need to learn out of contracts. We've been following the one that we got, that the dean gave us at the beginning of last semester, covering it through the book. We're going to cover absolutely every page in this book. We got through page 500 last semester. We're going to start at 500 and finish it up. And the reading assignment, by the way, it also is out on the Twin site. So you can keep track on a week-by-week basis. The cases that I'm going to call on are marked on here. If it's within those page numbers, you can be called on. So please be prepared. The final exam is going to be on April 6th, and it also will be multiple choice and at least one essay. For those of you that were in here last semester, I brought your exams. We're going to go over them at the end of class, as soon as we cover our new materials. That way, if you've covered your materials for today and you don't want to look at your exam, you're free to leave. If we've covered the materials in class and you haven't taken the exam, you also are free to leave, because you don't need to hear what the answers are before you take it. Any questions so far?
Can you repeat the name of that text that you just mentioned, the black letter?
Black letter. It's called Black Letter. Yeah.
I didn't know if you mentioned an author.
And most of them actually go into and discuss each and every one of the cases out of your book. It's the case holdings out of your book that you're tested on. Apply those to the facts that are given in the fact patterns, and if you've studied the cases and read the cases in your book, you'll know exactly what the outcome is going to be, because it's the same fact pattern. Most of them are.
I have a question. So for those of us who were in contracts 1, do you want us to say when you review we didn't take your final?
You're welcome to stay. You won't have a paper to go over, but you can hear the questions.
Okay.
I don't mind you doing that. Any other questions?
Can you, the black letter outline that you just referenced, did you say who the author was?
There are multiple authors, if I remember right.
Yeah, there was.
It's called Black Letter Series. You can Google it. It comes right up.
Okay. I'm just trying to narrow it down.
Google will narrow it down for you. Puts it in the top 3.
said something about convoy or something, convoyers or something.
Thank you. That's what I was going, that's what I was trying to
Convoys
get. Kiki.
Oh, that one's about 25 years old. I don't know if they've updated it. But it's another commercial guide.
I wasn't being an idiot. That's what I just couldn't phrase the question correctly.
She was listening better than you were.
Obviously.
Okay, yes ma'am.
The syllabus is not on my tween page, so I cannot see it.
Okay, I'll check and make sure.
Yeah, it is.
Yeah, I mean, on tween, did you add the course? Add contracts too? You're right. I apologize.
Okay, any other questions about the administrative stuff before we get into this week's materials? Oh, for those of you who are new to the class, Farnsworth, the 8th edition, is the book that we're going out of. And it makes reference to sections of restatement and sections of UCC that are in this book. And even though it doesn't always quote the restatement and the UCC in your cases in this book, you still need to read the restatement and UCC sections in this book, because that's what you're being tested on, is whether or not you understand those sections that are covered. We don't cover the entire UCC, only those sections that are listed in the book, because you will have a separate UCC class. The ones that we cover are generally the ones where they make comparisons between common law, contract law, and UCC, which is legislative law. Okay, now any more questions? The assignment for this week is really going to be quick because they don't cover a whole lot. They're very verbose. So I anticipate that we'll finish in plenty of time to go over the exams. All right, starting on page 501, form contracts. Some of the benefits of form contracts are right there in the second paragraph. It says like mass production. The key things are they make risk calculable, and the real security is the necessary basis of initiative and assumption of foreseeable risk. From last semester, you know that writing a contract is actually assigning risk to individuals, right? You remember the FOB terms in a contract, free on board? Who takes the risk of a product in transit? You're assigning risk. That's the reason you come up with terms in a contract. Unforeseeable contingencies affecting performance, such as strikes, fire, and transportation difficulties, can be taken care of if you address them in your contract. Standard form contracts at the bottom are often referred to as contracts of adhesion. You'll find out from the rest of the reading assignment the reason is because you don't get to negotiate those terms that are already pre-printed. That's some of the fun that you can have if you go to a car dealership and you want to buy a car and you ask them, well, will you take this term out of the contract? They answer no. And you know that, well, we talked about last semester, arbitration. The fact that arbitration, you give up your right to a jury trial. And if you want to take arbitration out of your agreement, you have to ask them because it's already on the pre-printed form. And if they say no, well, that's a term of adhesion because they're not willing to negotiate it. So that's why they equate form contracts with contracts of adhesion. Look in that bottom paragraph, several means of imposition which appear in combination. First, one enterprise may have a disproportionately strong economic power that it can dictate the terms to the weaker party. Last semester we learned that contracts are supposed to be arm's length negotiations between parties of equal bargaining power. Are car dealerships equal bargaining power to you? No, they're not. That's why they use their form contracts. The second one, there may be no opportunity to bargain over the terms at all. would you take this term out? And they say no, then you know that it's another term of adhesion. And finally, the standardized contracts are often used by a party who has the advantage of time and expert advice, i.e. they've hired a lawyer, and have no real opportunity to scrutinize and often no means of understanding the contract. That's the weaker party. Whether a party to a standardized contract can be reasonably held to have seen, understood, and assented to its unfavorable terms, and accordingly to be bound by them, that's the real question that comes up on all these terms of adhesion and form contracts. Look over at 503. Contract of adhesion was first used by Professor Patterson. There's the definition of it, if you want to mark that. Coined by Raymond, whatever his name is, in which one predominant unilateral will dictates its law to an undetermined multitude rather than to an individual. And they commonly come up in railroad, big industry, and they said resemble a law much more than a meeting of the minds. And sometimes they call that private law rather than public law. It's the law of whatever's in the contract. All right, our first class participation opportunity. Briefing O'Callahan. Mr. Golden, where are you? You want this first opportunity?
Sure, yes, sir. So, O'Callahan sued her landlord for negligence. And after falling in the courtyard of the building, and the landlord used the defense or claimed exculpatory clause in the lease barred the tenant from bringing the action. Is kind of the facts of the case. So the black letter law is contracts by which one tries to relieve himself from liability of negligence are generally enforced unless it would be against the public policy to do so, or there is something in the social relationships of the parties mitigating, upholding the agreement. And essentially what the case was about, or the main issue for this case was, can a contract which contains a clause allowing one party to relieve itself of liability for negligence be valid and enforceable?
Okay. This case just brings up all sorts of questions. Why didn't they just sue for breach of contract?
Because
It was a landlord-tenant, right? You have a written contract, so why didn't they just sue for breach of contract?
Wasn't there like a exculpatory clause about saying that the clause in
Yeah,
the
clause
lease
is that.
stated that the landlord or the property owner was not
That's
liable
what you
for
can't
any
get done.
negligence?
Involved in that.
1958.
Well, yeah, keep it in perspective. It was 1958.
money.
But why wouldn't you sue on the contract if it was a breach of contract?
Question, but was it a breach if that clause was in there that relieved the landlord of liability for negligence?
That's probably the very reason why the attorney went with negligence rather than breach of contract.
Okay.
Because the attorney recognized the exculpatory clause and said, well, we can't sue for breach of contract.
Right.
Let's go ahead and sue for a tort. Keep this in mind when you're doing your bar questions and out in practice is you've got multiple avenues to recovery for the same thing. One would be breach of contract in this case, for which there was an exculpatory clause, and the attorney probably recognized there wasn't much of a recovery for it. And then there's also negligence, which is a tort. So you have contracts and torts. He decided to go with the tort, and of course the court came back and said, well, there's this exculpatory clause that you signed as part of your agreement, therefore you cannot recover. Is that everybody's understanding of this case?
Yes.
Good. Now on the next page it says they've passed laws to change that, right? That's why you learn cases, is so you can learn what they did wrong and how they corrected it through legislation. Remember, we talked about that last semester, that whenever the court gets it wrong, the legislature has to go back in and fix it. This is one of those examples. I think you missed something on 506. Look at the next to bottom paragraph in the instant case is where it starts off. We realize that there is no precise definition of public policy or rule to test whether a contract is contrary to public policy, so that each case must be judged according to its own particular circumstances. That's another good general rule of law in there, is that each case is going to be determined on its own set of circumstances. You can't just make a general public policy and not apply it to each case. Now, remember also that what is public policy is usually going to be created by the legislature. That's when they pass laws to establish guidelines for what public policy is. Give you a crazy example. Child support. There is a law on the books that a parent has to pay child support for their child. Why is there a law on the books?
Just make sure to do it.
Because we have expressed a public policy that a parent has to support their child. The legislature passes law to create the public policies. Now, where this court went wrong, and I guess that's where the dissent kind of rails him, is that the courts are not supposed to legislate from the bench. They're not supposed to make up rules when it's actually the legislature that's supposed to define what public policies are. And if you're interested in that, it's con law, it's called separation of powers. Courts aren't supposed to legislate. Look at the note on 507. Most states now provide by statute the provisions that in residential leases, exculpating the landlord from liability of the tenant for negligence are ineffective. That's where they went and fixed it. Now it says that for residential leases. What other type of leases are there besides residential?
Commercial leases.
Commercial. And it doesn't say that they passed a law that says commercial leases can't exculpate the landlord. It just says it's only for residential. Why do you think there's a public policy for residential but not commercial?
Because of bargaining power in some cases and educational levels and business acumen.
And how about necessity of a place to live versus just a place to do business? All sorts of good reasons why they would want to pass a public policy prohibiting that is to give people a safe place to reside where they're not going to be injured by the negligence of their landlords. However, commercial, it's almost a caveat emptor, buyer beware, rentor beware. Next note, what's the difference between residential? We covered that. Look at the bottom. It says a court can construe language into patently not meaning what the language is patently trying to say. To give you an example of what they're doing, they look out and say that the sky is purple when it's clearly blue. Yeah, they even though you say one thing in the contract, the court may find a way to get around it. That's what they call judicial construction or statutory construction. They can find inconsistencies between clauses and throw out troublesome ones. It can even reject clauses as counter to the whole purpose of the transaction. Top of 508, the net effect is unnecessary confusion and unpredictability together with inadequate remedy. That's the last of the first paragraph. Look at the problem this was fun to look at. A landlord believing tenants often give credence to lease provisions, even if they are unenforceable, asks his attorney to prepare a waiver of tenants' rights that the attorney knows to be unenforceable. How should the attorney respond? Somebody walks into your office and asks you to do something which is clearly not going to be enforceable.
Well, if you know that it's
Tell them to
illegal,
save
you
their money and
can't
time.
do it. If you know that it's not valid.
Okay, if it's illegal, you can't do it, right? But is it illegal to draft something up which may or may not be enforceable?
But you should advise them that you think it may not be enforceable and
Let me ask you this, would it make any difference if your rent payment's due next day?
who's rent payment?
The attorney's.
Oh,
The attorney's rent is due tomorrow, and this client walks in and says, draft me up one of these. Does that make a difference?
He's saying tenants often give credence to these provisions even if they aren't enforceable. So I mean, just when they read it on the lease, that's going to curb some of their behavior. It's going to,
It might curb some of their behavior, right?
right. That's why he wants it, I would imagine.
What was that?
What was the question, if the attorney rent was due or the client?
Now, the client, the landlord, walks in and says, I want you to draft up a waiver of rights for the tenant to sign. Does the attorney draft up a waiver of rights?
Well, isn't that like fraud if you know that it's wrong and then you're presenting it to these people that have no knowledge of whether it's right or wrong?
Brings up a whole lot of ethical problems, doesn't it?
Right, because if you know it's wrong when you do it, then it is illegal.
Well, couldn't you just tell him, advise him of the risk, involved with doing that particular paperwork and go ahead and do it and because it's not illegal. It's just unenforceable.
All right, the answer is right down at the bottom. It says, a lawyer should not counsel or assist a client in conduct that the lawyer knows to be illegal, which, if there's not a law that says it's a crime, does that make it illegal? No, so drafting up a waiver of rights is not illegal, is it? Now, is it fraudulent? Is it possible that it would have the appearance of being fraudulent?
Yes.
It has the appearance of being fraudulent, doesn't it? When you're getting somebody to waive rights that you don't have the right to ask them to waive? So what should the attorney do in that case?
Say
Use their best
if it appears to
judgment.
be fraudulent or illegal, then they're bound by ethics to say, no, I can't advise them that we can't draft this document.
That's correct. The attorney should not do it if it has the appearance of being fraudulent.
Michael Cohen must have been absent on this day of law.
There's a lot of attorneys who are absent on those days. And when the rent check is due, there's a whole lot more pressure for you to go ahead and draft it up anyway. But you got to know that your reputation is going to follow you. If you start doing things which are questionable, you're going to get that reputation. All right, Graham versus Scissortail. Mr. Clayton,
Yes, sir.
all yours.
Fenix was an experienced promoter of musical concerts, and he entered into an agreement with the plaintiff to represent a recording artist. Fenix signed contracts, and the contract said that any dispute would be arbitrated by the union's international executive board. The concerts met with mixed results, and the parties were unable to reach a decision on the dispute. So, plaintiff filed for a breach of contract, and the defendant moved to compel arbitration and won. The defendant appealed, saying that the arbitration provision was unconscionable. Even though the defendant was very prominent and successful, the contract reduced him to the role of adherent, and the court found that this was an abusive contract, and then said that even though the defendant could have reasonably expected that there was a contractual provision requiring arbitration because of his entering into many of these contracts before, it was still unconscionable. the court still found that it was unconscionable because the arbitrator would presumably be biased in favor of one party.
Okay, so what was the dispute that they had?
Basically, the dispute was over the, there was a breach of contract, over the, I think they decided about arbitration.
Right, but what did they say was the breach of contract? What was the key fact that they were trying to get arbitrated?
It was a contract of
Was it like profits?
That money.
offsetting loss?
It was the profits on each
Yeah.
concert, wasn't
Yeah,
it?
that's the money.
Some concerts made money,
Right,
one of them lost money.
right.
And they tried to say that they could take money from the profits of one concert to offset the loss on another. And what you may have missed in here is that each concert was a separate contract. So can you take money from the profits on one contract and apply them to offset the losses on another contract? They're separate contracts, right? So what would you have told your client about taking money from one concert and paying it off on another? You can't do it. Well, it's not the contract. So did they breach one contract by taking the profits of it and paying off the debt on another?
Yes,
They breached two contracts, didn't they?
yes.
Now, why was it a term of adhesion?
Because
of
there
the
were
arbitration
clauses in
clause?
the contract that could not be negotiated.
That's one reason that it was a term of adhesion.
It was a standard form that was used by that organization, and when they used it, the AAF of M's constitution, they were not permitted to sign any form other than those issued by the union.
That's the
They
key
didn't have
part.
a choice.
You can't sign any contract but ours, and oh, by the way, ours, you have to submit all of your disputes to arbitration, where we get to decide whether or not we breach the contract. That's the arbitrator, one of the parties to the contract. Even though it was a separate group of individuals, it was the same entity to determine whether or not they breached it. So is that a term of adhesion? Absolutely. Everything was so one-sided, it wasn't hard for the court to find out. Look at the top of 509, that one, the very beginning paragraph where it starts off the court. Contract of adhesion, they give you a definition of it right there at the beginning of the case. It says, the term signifies a standardized contract which, imposed and drafted by the party of superior bargaining strength, relegates to the subscribing party only the opportunity to adhere to the terms or to reject it. There's your definition of term of adhesion, contract of adhesion. All right. The last paragraph, 2 judicially imposed limitations on the enforcement. The first is that the contract does not fall within the reasonable expectations of the weaker or the adhering party. That's number 1. And you need to know reasonable expectations. That comes up in your later cases. And the second is a principle of equity. And they say that if it's unduly oppressive or unconscionable, they will not enforce it. That's on the top of 510. All right, agreeing to a boilerplate. Look down there in the middle of that paragraph. It says, it's assumed that all parties know or are presumed to know the embedded clauses, the boilerplate, or what used to be called fine print. That's an important assumption that's made in every case, is that you know what those terms are. Now, why do you think you are expected to know what those terms are?
Because that's what you're agreeing to.
Well, because it's also assumed that you read something before you sign it. And if you can assume that you're going to read something before you sign it, then you can assume that you've read it and understand what those terms are. How many of you have actually read your cell phone contract?
So small.
It doesn't matter how small it is. How many of you have actually read it? Did you sign it? Are y'all crazy? You sign things without reading them?
Find loopholes to get out of that contract.
I got $200 back.
All right, the next page. One more thing is a blanket assent, not a specific assent, but a blanket assent to not only reasonable or incidental terms that the seller may have on the contract, which do not otherwise eviscerate the reasonable meaning of the dickered terms. Ooh, dickered terms. What does that mean?
Negotiated.
It negotiated. How many of you negotiated the terms on your cell phone contracts?
I thought they were non-negotiable.
Did you even try to get the arbitration provision struck out of it?
No.
All right, the example they give down at the bottom of 511 is a coat closet. You know what happened on the coat closet? They gave them a box to hold for them while they were at a party. You know what happened when they went back to claim it? They gave it to somebody else. Do you know how much they had to pay for damages?
$25.
Ultimately only $25, right? Because that was printed on the form that says we're only responsible for up to $25. And it was worth, what, several hundred? So thousand? So be careful what you... how many of you have actually read your parking garage slips? Now those are a whole lot shorter than your cell phone contracts. Have you read those? Not responsible for damages. I actually had a vehicle that got broken into in the parking lot by Frank Nelson building. And I went to them and I said, okay, show me the footage from your cameras because you've got cameras everywhere in here. I want to see the footage of who broke into my car. You know what their response was? These cameras haven't worked in years. You know what their responsibility was for my broken window? 0, because the little parking slip says not responsible for damages. All right, restatement 211, right there predominantly in the middle of 512. Make sure you put section 211 in your notes. At the bottom of that page, there's something called an umbrella insurance policy. Y'all know what umbrella insurance is?
Yep.
Is there anybody in here who doesn't know what umbrella insurance is? Well, good. We can test on it. Since everybody knows. The doctrine of reasonable expectations. Aha, there's the first time it's come up. For fine print or boilerplate terms, does it meet with your reasonable expectations of what terms should be inside of a contract? Because this terms of adhesion, has undue surprise as one of the elements that you can look at to get out of it. What do you think an undue surprise is? One which doesn't fall within your reasonable expectations of what the contract should have. Over to 513. It's fatuous to suppose that the policy owner had any part of the language of the policy besides filling in the blanks. That's kind of funny. Is it really a negotiated term if you only get to fill in your name on the blank?
No.
And the common wisdom is that very few insurance policy purchasers read all or even substantially all of the purchase contract. And it is not guaranteeable that they would understand it if they did. Now, how many of you have homeowners insurance? Have you read your policy? Most of it? Read it after the hurricane?
Yeah.
All right. How many of you have read your contracts? Some of you? How many of you read the exclusions part of your contract?
Yeah, that just made me mad.
That says what's not covered.
Everything.
fence.
Pretty much everything.
No, it's-
All right, if nothing else, please read stuff before you sign it.
But you
That's
would
what-
never sign anything if you read all these contracts, because I
true.
read them and then I start thinking, well, why would I sign this? But then you can't
Oh, well,
get a
that's-
cell phone or buy a house or get insurance.
That's not true at all. I sign things all the time that I have read, and it's got terms in there that I don't like. Here's the example. You walk into a car dealership and you want to buy a car. Doesn't matter if it's new or used, they're going to put an arbitration provision in your contract. So when you go back into the finance guy's office to sign all the paperwork, and he starts handing you these things and you already know what's in there, and you say, oh, there's an arbitration provision in here, because there's a little camera right up there in the corner, because they want to film you while you're signing it. You look up in the camera and you smile and you say, are you willing to take out this arbitration provision? And he says no. Then you've got evidence that it's not a negotiated term. Have you now just created the first step to saying it's a term of adhesion? Yes.
Yes. So what happens then, though?
Hold on, we're not done with our interview. You come across the next term and you say, well, the same term, the arbitration. You look up and smile into the camera. Is there any car dealership who will sell me this car within a reasonable geographic area that does not include arbitration? Smile. And he says no. You've taken the next step to showing that it is a term of adhesion, because nobody in the area is going to sell you a car without an arbitration provision. Are y'all getting me so far? So it's not that you don't read it and you don't sign it. You read it while you're smiling into the camera and following this list of things which show that the contract's not enforceable because it's of adhesion. They're not willing to negotiate the terms. They're not willing to give you the option to buy it for somebody else that does not include arbitration. And you follow your little checklist. And then if it ever comes down to the fact that you want to sue the dealership, and they want to say, aha, we've got this contract that says you have to arbitrate. Oh no, it's not a real contract. You wouldn't negotiate with me any of the terms. Let me see your video. Now, is that an enforceable contract for arbitration? Or is it a term of adhesion?
I'm a little bit confused because you signed it.
You signed it, but they wouldn't agree to negotiate anything.
But you signed it knowingly.
You signed it knowing that you can't do anything else. You're helpless at that point, right?
Right.
So now you've got adhesion.
You not film your own video?
No, I'm not doing my own. I smile up at their camera.
Their cameras may not be working like parking garage.
Oh no, they're going to make sure their cameras work.
Trust me, their cameras work.
And now here's the real kicker. And this was in this week's reading assignment. You know about the Federal Arbitration Act, right? That an agreement to arbitrate is going to be binding as long as you make it, save and except for grounds for breaches or for defenses to contracts. That's Section 2 of the Federal Arbitration Act. When we get to it in our reading assignment, I'll point it back out to you. So what defenses are there to contracts? Adhesion, right? So you agree to arbitrate unless the contract's not good because it's of adhesion, you're out of your arbitration agreement. You see that? That's why you take your checklist of all the different factors which are considered to be adhesion, and you smile in the camera and go through every one of those factors, and when you've gone through every factor and shown that they're not willing to do anything, you've established and now have video evidence proof that it's a contract of adhesion. So is that contract, or is that arbitration agreement enforceable? Now, you want to know what the ace up the sleeve is? If it's my wife's car, I'm the one that buys it. You want to know why? Because agreements are between parties, aren't they? If she's not a party to the agreement, she's not bound by it. That's why you go to law school, folks. You learn how to manipulate the law in your favor. And if she's not a party to the contract, is she bound by arbitration? No. I am, maybe, except for the adhesion part. But is she bound at all? No. Only parties to a contract are bound, right? That was last semester. You learned that, right? Everybody?
Question. So are you saying because she didn't sign it and you signed, or what are you saying? I'm trying to,
That's exactly what I'm saying. She didn't sign the agreement, so there's no agreement between her and the dealership.
but
There's an agreement between
the
me and the
title's in
dealership.
her name.
No, it's in my name. Oh, no,
Because I'm trying to figure out how is it her car, unless there's something
that's the one
written.
she drives.
But how can you prove that? Because they're going to look at who signed.
Well, if she's the one involved in the wreck, it's going to be her on the police report that says she was involved in the wreck, and if it was a defect of the car, your crash reconstructionist comes back and says, here's what happened, the car failed. But it's going to be her that's in the car, and yes, I'll put the car in her name or both of our names. But the contract is only between me and the dealership.
So they can't force her to arbitrate.
They can't force her to arbitrate.
That's interesting. That is interesting.
Well, remember, the Federal Arbitration Act says arbitration is enforceable save and except for defenses to contracts. And one of the defenses to a contract is, if you're not a party to it, you're not bound by it. Right? Contract's one.
We didn't get that. Sorry.
Really?
Yeah, we didn't get that.
Professor Bodie, so just to be clear, so adhesion is also a defense to an enforceable contract?
Yes.
All the time?
Every time.
Okay.
What else is a defense to a contract? Failure of consideration, not a party to the contract. All the stuff that we learned last semester that the contract has to have, mutuality of remedies. If the contracts don't have that, in fact, that was another one of the cases in this reading assignment, was that the employer had the right to recover everything, but the employee didn't. You remember that case? We're coming to it. So they can find that it's a term of adhesion because it doesn't give equal remedies. That's what, in contract terms, we call mutuality of remedies. All right, look also at design features right there in the middle of 513. Like small down payments, teaser rates, and other salient terms that variously characterize contracts for cell phone service, credit cards, mortgages, can lead consumers into entering costly contracts and various regulatory responses that might address the problem. How many of you ever heard the term 90 days same as cash? You know what they're doing there? They're teasing you that if you want to buy this $800 refrigerator 90 days same as cash, 90 days from now it's going to cost you the same $800 that it would cost you today. Everybody agree with that? Day number 91 it turns into $1,200 because of the interest that accrued from day one, retroactive, all the way up to whatever the current date is. You all seen those on your statements that says, here's the accrued interest, that if you don't pay this off on time, here's how much more you got to pay. That's one of those teaser terms that they use. Or 1 year, same as cash. You know what you do on those? You make sure it gets paid off first, right?
Right.
That design feature that I wanted to point out is to get you to sign it and to convince you that you're not going to pay any more than the exact price as long as you pay it off in 90 days. How many people actually get it paid off in 90 days? I think the number is less than 10%. So they make, what, on an $800 sale, they make $400 extra dollars 90% of the time? Is it worth it for them to offer that? Even if they're going to lose about $50 worth of interest by giving you free interest for 90 days? Oh, absolutely. Again, it's a calculated risk. That's what contracts are, is assigning risk to individuals. All right, 513. I chuckled at this. Suggests that lawyers in big firms who draft or reuse standardized terms do not always remember how a particular term became part of a boilerplate or even how the term is interpreted and for whose benefit? Now, how many of you, when you get out of law school, you want to collect some form contracts so you'll have something to go by? How many of you want forms for when you get out and start practicing? Those of you who don't have your hands up, you're lying to yourself. Everybody wants forms to go by. Now the problem is you got to read it and understand why the term's in there. And it's true that some attorneys at big firms, they don't have a clue why some of the provisions are in there. They just put it in there because it's there. If there's one thing you need to learn in law school, is that you question everything. Why is this term in here? And who does it benefit? The duty to read and the duty to disclose terms. The starting point in the common law rule that in the absence of fraud, one who signs a written agreement is bound by the terms whether he read or understood it or not, or whether he can read or not. So is it a defense to a contract that you are not able to read?
Yeah, I mean, if you were forced to, I mean, if you had no other option to sign the contract.
Hold on, you're getting ahead of us about the forced. Is a defense that you can't read? Well, I didn't know what that contract term said.
It depends.
All right, how many of you have actually run across people that are not able to read or write? Have you had to explain things to them? That's what they're supposed to do, is ask. Says, I don't know what this says. Can you tell me what it means? That's your duty if you don't know how to read and write. Ask what it means before you sign it. Now, if I read you something and exclude some very important terms, is that fraud?
Yes.
Fraud by omission, right? Or if I read a term that says one thing and I read it to say something else, well then that's just actual fraud, right? And there at the bottom it says, a person who cannot read has a duty to find someone to read the contract to him. Yes, ma'am?
My grandmother couldn't read, and when she did her will, the attorney had to explain everything to her. She signed with an X, and the witnesses and everything, it's still true, notarized everything, so when we probated, it's not a problem.
Yeah, when you sign with an X, you're supposed to have a witness actually see you sign with an X, and then print your name, and then sign that they printed your name and under the X that they were the witness to you actually putting the X on. And then if it's a will and it's got to be witnessed by 2 other people plus a notary, now you got a whole football team in there looking at a will. All right, go over to 515. Says the UCC or other statutes require that only particular information be conspicuous. We learned what conspicuous was last semester. Different font, different typesetting, whether or not it's all caps or underline or bold. It's got to stand out. Remember, they've gone in and invalidated some things that were buried inside the text because it was all the same font, wasn't made to stand out or be conspicuous in any way. So that's another way to get out of a term, is it didn't stand out. In fact, there was I think it was a footnote in this area that said for arbitration that it needs to either stand out or you need to initial it. Now that's a real good indicator that you've agreed to it, is if you initial right beside it, right? Another example about people who can't read and write, if you're going to go into representing criminal defendants, people charged with crimes, remember they're still presumed to be not guilty, right? Well, a lot of them can't read and write. So when you fill out the explanation of rights form, and you say, here, sign this, a lot of times they don't know what they're signing. You need to actually explain it to them and explain what their rights are before they waive them. The term with reference to what a reasonable person against whom it is to operate ought to have noticed, that's built into the UCC. that's what the reasonable expectation is, that they should have noticed it, or you got to make it stand out. A lot of other, I think almost every place has passed plain language statutes. In fact, they're actually requiring attorneys to use plain language now on pleadings and papers that you file with the court. Don't use any ancient Latin terms. Explain what it is that you're trying to do. Truth in Lending Act and the Consumer Credit Protection Act requires that you spell out what the annual percentage rate or the APR is on loans. So there's an example of another thing that's legislated, required disclosures. There's actually another one your book didn't mention, and that is the law that says that if you're going to make minimum payments, how long it will take you to pay it off making minimum payments. Anybody ever noticed that that's like 30 years? So if you don't make your minimum payments, it'll take you years to pay it off. And how much do you think that person or company makes during those years for you to pay it off? They make lots of money. And if you're late on a payment, they charge you a late payment fee, which is just extra money.
Isn't it also included in credit card contracts? Isn't that also covered by the Lending Act?
It is. Your credit card statements as to how long it's going to take you to pay it off.
It has like a little box.
Yeah, they make it pretty, they make it stand out pretty good. Some people would call that conspicuous, right? Where you make it stand out. All right, sources of policing, the courts, legislature, and agencies. Under judicial measures, the courts have recognized the distinction between dickered terms and boilerplate clauses. Remember, the boilerplates are going to be okay as long as they're within the reasonable expectation. If they're not within the reasonable expectation, then they can be stricken. Statutory measures, again, that's where the legislature's passed laws that says these terms have to be in contracts or these terms cannot be in contracts. One of the most recent changes to the landlord-tenant law, which is several years ago now, one of the provisions that they would put in the landlord-tenant or in your leases, particularly your residential leases, is that they have to hire an attorney to come after you to collect your overdue rent, that you will pay their attorney fees. Well, the new Landlord-Tenant Act has taken that provision out that they cannot charge you the attorney fees just to come after you for unpaid rent. Now, there are provisions where they can, but that's an example of legislating certain restrictions into contracts. Now, how many of you are familiar with Article 1, Section 10 of the U.S. Constitution? Anybody? All right, who wants to Google it real quick?
I will. Article 1, Section 10.
Article 1, Section 10, and I think it's the last sentence in it.
No state shall enter into any treaty, alliance, or confederation. That one?
No, not that one. It's the last sentence about contracts.
Powers prohibited of states, no state shall enter into any treaty, alliance, or confederation, grant letters of RP and reprisal, coin money, emit bills of credit, make anything but gold or silver, appoint tender and payment of debts, pass any bill of attainder, post facto law or law impairing.
Impair the obligation of contracts.
Impair the obligation of contracts. That's in Section 10, isn't it?
It is.
Okay, no state shall pass any law impairing the obligations of contracts. Now, what does that mean? Let's look at the landlord-tenant law and whether or not they can strike out provisions for the landlord to collect their attorney fees. Is it constitutional for them to pass a law that says you can't collect attorney fees in landlord-tenant cases?
Say what you said again, that no state shall pass.
Laws to impair the obligations of contracts. Just Article 1, Section 10, it's buried in there.
And it says prohibits the states from interfering with private contracts.
Yeah. So, what is it constitutional for a state to pass a law that says you can't have these terms in your contracts?
Well, yeah, because they're looking out for the people who don't have as much bargaining power.
Okay.
And that's why they can't do it.
It says something about the founding fathers intended it to protect contracts providing for payments of debts.
I thought something about water. I think
Well, it's interesting that it's applied there, but later, I mean, you have other areas where the contracts are interfered with, such as in certain states, they can't have balloon payments, so they can't have. But I mean, maybe that falls under different finance rules, I don't know.
What about federal trade? The federal trade, FCC, no, FTC, Federal Trade Commission. Don't they have a whole bunch of rules about what you can and cannot put in contracts? Do you think those are constitutional? Just something to think about. Yes, they are to protect the public safety, aren't they?
state demeanor for federal. I mean, we're gonna get into it one way or the other.
Okay, look at states. What about state regulations?
It says something about the state legislature, it applies to the state legislatures, but doesn't apply to court decisions. See, something like
Right,
that.
courts are free to interpret contracts the way that they need to in order to do justice. But it applies to the legislatures, who, by the way, have passed laws that says you cannot include certain provisions in your contracts.
Is that like Dodd-Frank? Is that the same?
Who?
Dodd-Frank legislation?
Does.
For bank.
Does.
For banking?
For banking.
Oh, I'm not familiar with banking. But if the banks, if they pass laws that says you can't include certain contract terms in your banking contracts?
Is that like preemption that the state is overruling?
Yeah, it sounds like the state's overruling a U.S. constitutional provision, doesn't it? That's just food for thought, that if ever you find yourself trying to defend against a breach of contract case, you might as well pull out and say, well, federal law says, U.S. constitutional law says you can't impair the obligations of contracts. All right, going on to 518, administrative measures. There's where the FTC establishes some of their guidelines about what you can and cannot do, like unfair trade practices. How many of you have heard of the term bait and switch? Last semester, right? Entice them to come into the store to buy a fur for $10 and not have it because you're not female and try to sell you something else. Y'all do remember that case.
Yes.
Can't put those extra terms in there that says we can't sell it to you because you're not female. All right, Doe versus Great Expectations. Ms. Benson.
I'm ready.
Go ahead.
The plaintiff entered into a contract with the defendant. The services to be provided by the defendant under the contract included posting the client's video profile on the internet website, where other clients of the defendant would have the opportunity to look at them, and the clients could then contact other clients on the site for purposes of dating or social interactions. The plaintiff paid the defendant, one of them paid him $1,000 and the other paid him $3,700, and they received no social referrals from the defendant. Under the dating services law, a dating service that did not guarantee a minimum number of social referrals per month could charge a max fee of $25 per month. And by the time the plaintiff sought relief, one of the contracts had expired, but the other one remained in effect. The questions before the court were whether the statute applied to defendant's internet-based data service, and if so, whether the violation of the statute entitled the plaintiff to cancellation of the unexpired contract and full restitution of the amounts they paid to the defendant, including the $25 that could have been lawfully charged. And the rule is a court may award full restitution damages in an action based on violations of a statute designed to protect consumers.
Okay, so this was a New York state law that they were wrestling with, right? The dating service law? Now, this is Great Expectations. How many other dating services are there? Can't count how many there are anymore, can you? Funniest one I've seen is on TV. It's farmersonly.com. I'm not sure why you'd have a farmersonly.com, but if they think there's a market for it, let them go for it. Some of the things that the court wrestled with in this case, other than the analysis of whether they get a full refund or not, that was actually a pretty good analysis. Everything over the $25 is automatic, right? Because the law prohibits that. But then do they get the rest of the $25 per month? That analysis was that they did. Look in the middle of 521, general rules that judges are granted the discretion under the proper circumstances to report instances of illegal conduct revealed in the course of proceedings before the judge. That's true everywhere. Judges have the authority to report illegal conduct. Yes, ma'am.
So for this case, was the argument about the $25? I mean, that would give them the full, right? So was it?
That was part of the argument.
Because it seemed like they were arguing over the $25 versus necessarily, I mean, it's like, that's the part they didn't want to give back.
Well, no, they were arguing over the whole thing.
Okay.
They entered into the contract and some dope paid over $2,000. Imagine how desperate they must have been. And the other one was just $1,000, right?
I think I focused on maybe the full part, like it seemed like they were.
No, it's just,
I'm always.
well, it was that they asked for full restitution, but it seemed like it was automatic as to anything over $25 a month, and that there was no question, and it looked like they even conceded the fact that anything over $25 a month is automatically due to be refunded.
Yes.
So then the court had to look to see whether or not they were entitled to $25 a month, on top of what the party said, yeah, it was illegal to charge more than $25 because they didn't make any referrals. Now, how could they have gotten out of that? One suggestion a month, right? Because the law says no more than 25 if you're not going to do anything. If they'd have just matched up one profile, even at random, and said, try this person, then that would change the facts of the case. They could ask for the whole price, it looked like, under their dating service terms. So they struggled with the $25 a month. And the first contract for $1,000 was just for a year. So they were struggling over $600. No, $25, $12, $300. $300 took this much time and on appeal. They appealed $300. You know how much you're going to spend for an appellate brief? The cheapest is probably going to be about $5,000. All to fight over $300.
It's the principle of the matter.
Some people just
Now, did y'all hear that? It's the principle of it. When you have a client that comes into your office and said, it's the principle of the matter, that's when you say that will be cash up front. Because I'll fight for your principles, but I'm going to get paid. Later in your reading assignment, it says that attorneys won't often take cases that don't have financial incentive on it. Folks, when I first started practicing, I kept a stack of small claims forms in my office, so when somebody would come and see me, and the amount that they were fighting over was under $1,500, which was the amount for small claims back then, I'd hand them the form and say, fill it out. Go represent yourself so that you get all your money. Hey, doesn't that sound a whole lot better than this is not enough to even get me paid? Hand them the form and say, that way you get all your money. It's it's making it sound like it's advantageous for them to do it, right? Look at unconscionability starting at 322. 522. On McKinnon versus Benedict, one of the last cases we covered, they said the consideration was, quote, so gross as to be unconscionable and bar to the plaintiff's invocation of the extraordinary equitable powers of the court. Well, if you have consideration which is so gross as to be unconscionable, you might have an unconscionable contract. It's a good way to start it off. UCC 2-302, we cover it again, this time in the terms of unconscionability. So put it in your notes because it's test material. 523, the principle is one of the prevention of oppression and unfair surprise. That's your two objectives. And then at the bottom, the court found that it was too hard a bargain to entitle the plaintiff to relief in a court of conscience. Keep in mind that courts are going to still have a conscience. And if something shocks the conscience, which is another term of art, then you're not going to get relief on it. Restatement 208's at the bottom. Starting in the last paragraph of 523, this was a good observation that lawyers, business lawyers, tend to draft to the edge of the possible. Sometimes they go over that line, don't they? When you want to draft something up to the full extent of your client's rights, and sometimes you infringe on somebody else's because you've gone too far, that's what business lawyers do. Engineers, on the other hand, when they design something, they don't want to design something to the extreme. They want to have margins of safety. So they're not used to going to the very edge of what is possible. They want to design safety into it as well. Look at our space program. They have redundant systems, right? Because they can't afford to have one system fail. They want to have a backup system in place because what's at stake? People's lives are, right? And if one system fails, do you want it to kill the person that's on the spacecraft? So it shows you engineers are more protective than lawyers are. The practice of business lawyers has been, however, has grown to be so in the course of time to draft to the edge of the possible. All right, unconscionability, the two views. Look in the middle of the paragraph that says an explanation. There are two types of unconscionability, procedural and substantive. The reason it's important to notice it here is because they distinguish it later in your reading assignment. Procedural and substantive unconscionability. The procedural unconscionability as fault or unfairness in the bargaining process. That's the procedural. And the substantive looks at the outcome. What's the result? And such as consideration which is so inadequate as to be unconscionable, that's a substantive unconscionability because it's the result. The consideration is inadequate. Procedural, how you meet the bargaining process itself. Procedurally, if I hand you a form contract that says take it or leave it, do you have procedural unconscionability? What's the process? Take it or leave it, right? Can that be construed to be unconscionable? Probably can, right? And then down at the bottom it says beyond unfair surprise. That's the test for unconscionability, is unfair surprise. Remember our case last semester where the guy retyped up a contract but made one key change? passed it off as being the same one that was handed to him? Was that unfair surprise to find different terms in it?
Yes.
It is unfair surprise. All right, 525, defect in the process of contract formation, be it duress, fraud, or undue influence. So how did you get the contract? Was it by duress? That's going to be unconscionable. Fraud and undue influence, unconscionable. These are defenses to your contracts. Last sentence in that paragraph, if there's one thing in which more than another public policy requires is that men of full age and competent understanding shall have the utmost liberty of contracting, and that their contracts, when entered into freely and voluntarily, shall be held sacred, and shall be enforced by the courts. In plain English, it means if you're dumb enough to sign it, you're going to be bound by it. All right, Williams. Ms. Williams. Williams versus Walker Thomas Furniture. Ms. Williams. Latrice Williams? It's the only one I have on the roll. Who's the other Williams that's in here? All right, Ms. Latrice Williams. Can you speak up so everybody can hear you, please?
Items to customers on the lease agreement, we provide that customers would make a series of installment payments. Walks would retain title to the items on all payments that were made, at which time the title would pass to the customer. All Walker's lease agreements also contain a unique provision that every time a new item is leased by a customer, a balance will become due on all items previously leased by that customer until the entire balance for all items is liquidated. The effect of this provision was that if a customer defaults on his most recent purchase, Walker could attempt to repossess all previous purchases by that customer. Williams purchased cereal from Walker and followed shortly after. Walker sued to recover on the cereal as well as other items previously purchased by Williams. The trial court granted judgment for Walker and the appellate court affirmed. Williams and other defendants appealed to the District of Columbia Court of Appeals.
So what happened?
The judge decided that no, he said when an element of unconscionability exists, when the contract is formed, the contract is not enforceable.
Okay, that's correct. Everybody got that? Now, describe for us what are the circumstances, or what do you call it, when I want to buy something, but I give you the right to repossess it if I don't pay for it?
Lease to own.
Well, no, that'd be a purchase, right? And they didn't want to give you any ownership interest in it, so instead of calling it a purchase agreement with an installment contract, they said it's lease to own so that they retain title of it the whole time. So who owns it? The company owns it until you pay every penny for it, right? So that's the number one trick that their lawyer used, is that They didn't actually sell anything. They just rented a whole bunch of stuff. Are there any companies out there now that rent to own? There's a whole lot of them, right? And so now you can expect to see contracts where it's going to be a lease until you've paid for everything and then title transfers? Well, if I retain the right to go out and pick something up when I sell it to you, and I retain the right to pick it back up if you don't make payments for it, that's called collateralization. And that is where the property is collateral to the loan. Y'all have heard of collateral, right? That's what it is, collateralization. Under the UCC, they call it a purchase money security interest, or a PMSI. You'll get that when you get into your secure transaction or secure transactions. But nonetheless, it's a security interest or collateralization. It says you have the right to go pick it back up if they don't make the payments for it. Now, the second nasty trick that they pulled in here is not only are they saying that it's rent until you pay for it, the second trick in there was that they have the right to go back out and get anything you've ever purchased.
Unbelievable.
Now, that term is called cross-collateralization. And that is where you are getting the right to go and pick up something which was not subject of the original loan. Everybody got that? Cross-collateralization is other collateral that's not collateral of the original agreement. That's how you get the term cross in there. Yes, ma'am?
So if you default on one,
They can come out and take everything. And you will still see cross-collateralization contracts out there. They're still there. Sometimes attorneys do that. If you don't pay your fee, I can come out and take your car.
I saw what you're doing, see there.
I recommend that you don't do that. However, people are still out there doing cross-collateralizations. So why was it unconscionable? Because nobody in their right mind would give away the house, right? Did they have any ability to negotiate that? No. And what was one of the circumstances that they looked at? These were poor people who couldn't afford to buy stuff. The only way they could buy it is if you extended them some credit. And then I think it's somebody in their right mind would not sign an agreement. Well, when you're in a position where you're under extreme economic duress or hardship, you're willing to agree to almost anything, like a you buy it here, you pay it here car place. How many of you have driven by at least one of those on your way into school this morning? Buy here, pay here. You know what their interest rates are? Terrible. I'll give you another example. Bankruptcy court. Back when I was sitting in your chairs and working for the standing Chapter 13 trustee as a runner, I would see these people who were buying cars, and you know how much their interest rates were?
29%.
For cars? How much do you think is a good interest rate right now for a car?
About 4%.
4%? 4.9?
Oh, my bank was doing a special on that. Like if you refinance with them, you get 1.9.
Yeah, some places are offering 0 interest for the first year.
And then they go back and keep.
Is that one of those teasers we talked about?
Yeah, my credit card did that and up to my limit.
Yeah.
And if you don't pay it off, it's 29.99%, right?
And it goes back to the first day you took out
Yeah.
the loan. Yeah.
So they're enticing you to come into it. The highest interest rate I think I saw while working in the bankruptcy court was 36% interest on a car. And do you know what reason they used to justify 36% interest? It was risk. The car lender was taking a risk to loaning money to somebody who's already been shown to be financially insolvent. So did the court uphold the 36%?
No.
Absolutely. Because it was a measured risk.
The state max used to be 24.9 because when I sold cars, that was the max that we could do.
In bankruptcy court, it was 36. And I think in armed services, it's 36 now too. By the way, excessive interest rates, that's called a usury law, U-S-U-R-Y, usury. And in some states, they do pass laws that says this is the maximum amount of interest that you can charge people. That's what a usury law is.
They have that in Alabama?
Not that I'm aware
I
of.
know they do in California.
Not that I'm aware of.
Our
Yeah.
lobbyists are fighting in this thing.
In fact, there's a funny story about Alabama. Back when it was a territory, after Mississippi had become a state and Alabama was just an Alabama territory, they had some usury laws in place. And when Alabama became a state, it adopted new laws. Once you're a state, you have the right to pass laws, so they did. Well, as it turns out, there was a lawsuit filed by somebody that had interest rate, which was Alabama pre-state, and the court had indicated that whatever the law was at the time you entered the contract is the interest rate you have to pay. And they were so upset by the fact that the judge upheld the interest rate on that contract that they went through and changed the judicial branch of Alabama government to where they are no longer appointed judges, but they are elected judges. And they have a term limit of 6 years. So believe it or not, Alabama used to have appointed judges, just like the federal government. But again, the legislature has the right to go back in and make corrections. And in that case, it wasn't just passing a law to protect consumers, it was restructuring the entire court system.
So the person who wanted that law change was probably a legislature who got on the wrong end of the ruling.
I don't remember who he was. That's just another example of how they can change the laws. Cross-collateral, and it's also called a Dragnet Clause. You'll find that on 529. Dragnet, as by you can cast the net over anything you can repossess and drag it in. Okay, at the top of 530, Unconscionability talks about a shopping radius. The shopping radius of poor people is small. For rich people, it's large. You can, there was one crazy fellow that wanted to buy a house, and he had it disassembled over in France and then reassembled in Asheville, North Carolina. Y'all know who they were?
It was the Vanderbilt.
It was the Vanderbilts. You know the name of it?
Biltmore.
It's called the Biltmore. When you have more money than you know what to do with, you can go over to France and pay to take something apart piece by piece, ship it over to Asheville, North Carolina, and then put it back together. Now, can you imagine buying a house where the only thing you can afford is a mobile home? How far away are you going to travel to get your mobile home? Coleman, maybe? They got a lot of them in Coleman. Huh?
Tuscaloosa is about as far as you go.
Okay, excuse me.
He said it.
And you know, having been to both Tuscaloosa and Auburn, I find that the housing in Tuscaloosa is usually apartments, while the housing in Auburn is usually mobile homes.
Thank you. Have you been to Auburn recently?
My first two semesters at
They're
Auburn.
luxury condos.
There are, but there's still a lot of mobile home parks. And a lot of parents rent those out for their kids to stay there while they go to school.
Lived in Barron.
But let's not get into Alabama, Auburn. Go to the next thing down at the bottom. After your shopping radius, which is another factor about unconscionability. Remember, we're pointing out the factors that they look at. Legal aid lawyers report that they can often settle complaints of individual consumer debtors on favorable terms. Y'all familiar with what legal aid lawyers are? They actually create legal aid organizations to help those who cannot afford to hire lawyers. In fact, the Alabama Civil Justice Foundation gets grant money every year from the Alabama State Bar to provide legal services to the poor. The money that they make on your trust accounts on your IOLTA accounts. Attorneys don't get interest on their accounts. Whatever interest is earned goes to one of these two nonprofits. And they are the ones who contribute the money for, a lot of other places contribute money too, but that's one example. They contribute the money to legal aid lawyers. Not only that, but they also have pro bono lawyers. In Jefferson County, they have lawyers that go up to small claims court every Friday to assist pro se litigants in getting their issues resolved. All right, distributive justice. Next is unconscionability and incapacity. The funny thing about the unconscionability and incapacity is that English seamen as members of a happy, fun-loving race, but certainly not able to be trusted to take care of themselves. Who else cannot be trusted to take care of themselves in today's society?
Drunk people.
Drunks? How about children? Well, children are supposed to be raised by their parents, right?
The elderly.
So do you protect children because of incapacity? Yes. How about incompetence? Ones who've been adjudicated. We already talked about that, right? If they've got a guardian, you have to give the guardian notice. And then there's rent to own again. The poor and the vulnerable is the bottom of that page. Price unconscionability. Ms. Savage.
Yes, sir.
You want to do Jones versus Star Credit?
The plaintiff were welfare recipients, there we go, and endorsement has been sold in the freezer for $900. Later we found out that the retail for the freezer was actually $300, but it wasn't just the $900 because there was also additional charges that the plaintiff will have to pay, totaling $1,439.64. The plaintiffs had paid a total of $619.88 towards the balance. The court found that it was unconscionable because of the increased price. It was an extreme price difference that they had to pay. So it was an unconscionable contract.
Okay, so what did the court end up ruling in the end?
They had to pay back the $619.
Now, they had already paid that much money, right?
And they ruled for that amount for the Joneses.
Right. In other words, they said you don't have to pay any more. What you paid is enough.
Okay.
They didn't give the
So they didn't give them a judgment of $619.
No, what they said is what you paid is enough. You don't have to pay any more. And the credit company that sold them this refrigerator for $900 just has to go ahead and take the $600 and something that they've already paid and walk away from it. Yes.
One thing that confused me about this case, though, is if you remember last semester, we went over a case, and it's slightly different.
Selling radars to the government?
I don't know. I think it was the land where the guy, the wife tried to go back and say that the husband sold the land for too low of a price, and they said it didn't matter because he had a lucid moment, so he was able to, that contract was enforceable. So that's what confused me about this. Why is it that the government or the judicial system can step in and say, okay, this contract is unenforceable because you charged them too much, but they won't step in and say that you did not charge this person enough money, and because that plot of land was worth so much more than what you guys agreed on, I'm going to step in and make this a fair agreement. So that kind of confused me.
You have to look at it as the court doing the right thing in the right circumstances. Now, did the guy back then have a lucid moment and agree to sell the land at whatever the price was?
That's what they said.
It's what they said. But in this case, would somebody in their right mind agree to pay $900 for a $300 refrigerator?
Will someone in their right mind sell a plot of land for a lot less than what it's worth?
I wouldn't worry so much about what he had agreed to then, in this example where you agree to pay 3 times the original price, the court can find that it's unconscionable. And then plus the added fees.
Isn't that like price gouging?
Well, it was price gouging, and it bordered on being predatory. In this case, what you need to know about the holding on this case is that the court kind of basically redlined their agreement. We call it the blue pencil rule. If you haven't seen that mentioned in your textbook yet, blue pencil rule is an actual term that says the court has the ability to rewrite a contract in equity so that the total price that they paid is the total amount that they've already paid, and that's all they owe. So they blue penciled out the extra payments. It's court of equity making the decision here. Look at the meaningfulness of choice is essential to making a contract, and it can be negated by gross inequality in the bargaining power. They go through a whole bunch of different factors in here, and it's worth pointing out probably from the top third of 533 down to the bottom of 533. They're all the factors that the court considered in whether or not this was an unconscionable contract. And those are factors that you need to be aware of when you get a fact pattern that says, is this going to be unconscionable or not? Or is it going to be enforceable? 533. They start off with whether or not the contract can be unconscionable as a matter of law. No other provision in an agreement more intimately touches on the question of unconscionability than does the term regarding price. Fraud in the instant case is not present, nor is it necessary under the statute. Whether under the circumstances of this case, the sale of the freezer unit having retail value of $300 for $900, $1,400 including credit charges and $18 sales tax, is unconscionable as a matter of law, and the court says it is. So I guess another key thing to point out is who makes the determination as to whether or not something is unconscionable as a matter of law? The judge, because the judge makes the decisions about the law, the juries make the decisions about the facts. So if you're going to say as a matter of law, then the judge is going to determine that it's unconscionable rather than having to wait for a jury to do so. Yes, sir.
Well, they refer to the UCC. I guess they use an act to say, okay, UCC says a court can revise a price. Is that? But they're not saying it's an equity case.
It is an equity case.
But they're using that to say this is the reason why a court can look at the price. They do the UCC.
Yeah, the UCC grants them the equity powers. It's important to note, like on small claims cases, and you'll get this in civil procedure, the powers of the courts in which cases are brought vary. And in Alabama, we have two different trial courts. One is the district court and the other one's the circuit court. Circuit court is a court of general jurisdiction, which means unless there's a special statute that says you have to bring it in a particular court, then you file it in the circuit court. That's what general jurisdiction is. Now, district court, it has a jurisdictional statute that says if you have any claims under $6,000, you have to file it here. And then not only $6,000, but anything that's less than $3,000, not only do you have to file it in district court, but it's going to be under a docket called small claims rather than district court, and then you use small claims court rules rather than district court rules. And the small claims court rules are even smaller and less complicated for plain individuals to go in and actually litigate their own disputes. That's why you keep the stack of small claims forms in your office. You might even give them a copy of the small claims rules that says, here's how you present your case in court. Good luck. And by the way, you get to keep all your money. It used to be $1,500. They bumped it up to $3,000, and now I think it's $6,000.
6, yeah.
In Madison County, it's $9,999 for small claims.
Well, they have different filing fees depending on how much. It's $6,000 is the cap for small claims, but anything under $3,000 is one filing fee, which is like $99. And then if it's between $3,000 and $6,000, it's another filing fee, which is somewhere between, you know, the $99 and whatever they charge in circuit court. But it's a small claims, and it's an abbreviated procedure and relaxed rules of evidence and a whole bunch of other things. Yes, ma'am?
When did they change it from 10,000, or is it just 10,000 is the cap for district court?
10,000 is the cap for district court. 6,000 is the cap for small claims, which is just one of the dockets in district court.
Okay.
And I'd say 4 or 5 years ago, they raised it from 3,000 to 6,000. So it's still small claims. What I was trying to get to on that is that ordinarily a case that's brought in district court, the court doesn't have equitable powers. Not like the circuit court does, because circuit court's court of equity, district court is not. They can't exercise any equitable powers except those that are granted by statute. Lo and behold, the UCC says, for sales of goods which are transportable, then these are some of the powers that the court has under the UCC, which, by the way, some of them have to be equity powers. Everybody got that? Otherwise, the court can't generally exercise equity powers. The notes on 534, the net cost for the refrigerator freezer plus a reasonable profit, in addition to the trucking and service charges necessarily incurred, and a reasonable finance charge. That was kind of the limits of what they said that they could recover. In cases of fraud and high pressure in in-home sales, there's a federal law about in-home sales that says if somebody comes to your house to sell you something, you have the right to rescind that contract within 3 days. So what about those people that come and try to sell you encyclopedias? Have they stopped doing that yet?
No, well, now they're selling like some kind of learning software.
That, and I get the doorbell.
If you just want to get them out of your home, here's how you do it. You go ahead and sign that contract, and as soon as you get them out of your house, you write them a letter that says, I hereby rescind. Fastest way to get them out of your house. Because if it's an in-home sale, you have the right to do that. High pressure sales, buy it now. This price won't last forever. This offer is good until you walk out that door. Is that unconscionable?
You have no time to
You shouldn't be pressured into doing anything, right? All right, a comparison between for credit price and the value measured at the price in which similar property or services are readily obtainable in credit transactions by like consumers. That's another factor. Price comparison between those two. And if we're going through and making a list of all those things which are unconscionable, this is one of your factors to look at. Gross disparity between the two is to be considered, whether or not it's unconscionable.
Which page is this?
Bottom of 534. Price disparity, but it has to be gross disparity. So what is exactly gross disparity? There's one answer. It's the best answer in law school. It depends on what the judge thinks is gross disparity, right? How about this? The bottom it says price suggested the price exceeding the average by 100% is deemed to be prima facie unconscionable. That's just in one state. The answer is there's no uniform answer. So what is gross disparity? Really is, it depends. Depends on the state you're in, it depends on a whole bunch of other factors. There it is, capping annual interest rate on credit extended to military personnel, 36%. They even give you the U.S. code site for that code section. Billable hours. You gotta love it when attorneys get in trouble, right? They billed a client $2 million in legal fees for work done in an 18-month period. And the funny part about it was, they're not even the ones that did the work. They brought in another attorney from outside to do it. Is that unconscionable?
Yeah.
If he's got more than 2,000 billable hours in a year, then you can probably assume that they're double billing. And you can't double bill. All right, unconscionability in franchises. Y'all are going to love franchise agreements. There's a lot of law made with them, one of which is Burger King versus Rudzwitz. You'll get that in civil procedure. It's a Burger King franchise.
We saw that case in our legal writing class.
Did you really? So you know you can be required to go down to Miami, right? Gross disparity in bargaining power for franchisees. Now, who are the usual contract parties to a franchise agreement? The franchise owner, right? The one who's giving the person the right to sell the products under a particular trade name. And then who else is the other party? Somebody who's just trying to make money by selling products that they think there's a high demand for. So what do? They spend millions of dollars for the right to use the trademark name, and they want to have products available in their community, and hopefully it'll be a great demand for them. Is there a great demand for Burger King today?
No.
Is there a great demand for Chick-fil-A?
Yes.
Yeah, particularly in the South. How much do you think a franchise would cost you for Chick-fil-A?
It's 10,000 to start up, and then they pay all the other fees.
But you have to graduate.
Well,
Plus the
yeah, you have to be
percentage of sales.
accepted, but it's only 10,000 when I was shopping.
Now, who requires you to go get educated on how to use a franchise name and franchise products?
They do.
The franchise owner. Do you think that they would be willing to negotiate out the term that you have to be trained on how to use their products? So who has the superior bargaining position?
And let me also
All the
say,
franchise owners do, right?
Professor Bodie, you pay them 50% of all of your earnings, too.
Chick-fil-A?
You do, and that's 15% else. Some of us just asking, I just looked it up.
50 or 15?
50% of your earnings.
One half?
You pay one half, and then you rent something else at 15% from it.
Makes you want to stay open on Sundays. Yes, ma'am.
She's in with a Federal Arbitration Act, and so she has she can't even buy a container like you. She gets caught, buying a container from the dollar store, or balloon from the dollar store. She has to buy it from Federal Arbitration corporate. So, they're the real rights.
So that brings up a question, have they created themselves a monopoly? Are monopolies illegal?
Yes.
Sherman Antitrust Act, right? But it's a matter of what you agree to. Remember, you can sign a contract for anything. And if you want to sign a contract for them to, where you can only buy your stuff from them and serve things in the way that they want you to serve them, you can be required to do that. Automobile Dealers Day in Court Act on 537. They passed that law because automobile manufacturers had a far superior bargaining position than automobile dealers. The Petroleum Marketing Practices Act, again, passed because there was a superior bargaining position. Now we get to the best part of our lecture, and that is arbitration. I think that's the last thing we're covering, isn't it? Mm-hmm. There's the Federal Arbitration Act. In the second paragraph, save for, upon such grounds as exist at law or in equity for the revocation of any contract. That's federal law. Section 2 of the Federal Arbitration Act. Save for, upon such grounds as exist at law or in equity for the revocation of any contract. Now that's federal law. Let's talk about what that means just for a minute. This federal law passes that says that you have to arbitrate except for any grounds as exist in law or equity for the revocation of a contract. Now, what law determines whether or not you have grounds to revoke a contract? Well, that would be contract law, right? And who spells out what contract law is?
The legislatures.
Which legislatures?
State.
State. There's the trick to Federal Aviation Act, or Federal Arbitration Act, is that every contract to arbitrate is enforceable unless there's a state law ground which gets you out of the contract. And so what you need to know is that whatever state you're in, here it's going to be Alabama, whatever there are grounds for in Alabama to get you out of a contract, you can get out of arbitration if you know your state law contract grounds. One of which is unconscionability. What's another Alabama law for getting out of a contract? Duress, fraud, incapacity. You're not old enough to sign a contract, or you have been adjudicated incompetent and your guardian didn't sign the contract. Folks, everything you've learned last semester and this one so far about what does a contract have to have, including consideration, failure of consideration is a ground to get out of a contract. So while arbitration can be required by federal law, state law gives you the way to get out of it. Okay, there's the term one-sided, so one-sided as to shock the conscience. That's toward the bottom of 538. And earlier we had a quote that said that it was a court of conscience. Well, this is where it comes into play. If it shocks the conscience of the court's not going to enforce it. There's one that says they do not permit full recovery of damages for employees while placing no such restriction on the employer. That is a mutuality of damages, and that's a reason to get out of your contract. Look in the middle of 539, the paragraph that starts off, in Shubin v. William Lyon Holmes. Somebody said and did things to hurry or pressure Shubin into signing documents placed before her without having time to carefully read the content and no realistic opportunity to suggest modifications. Procedural unconscionability was established. There's your factors for procedural unconscionability. Were they hurried? Did they have a chance to read it? Did they have a chance to negotiate? How about the next one down, the next paragraph? They don't read or speak English. They only read and speak Spanish. Is that grounds to get them out of a contract? That was a good answer. C. Severability, the next section down. This is also about the blue pencil rule. Severability says that if one term is found to be unconscionable, that they can sever it from the contract and leave the rest of the contract in place. That is what the blue pencil rule is, striking out provisions and leaving the rest in place. They also say they recognize a state's strong public policy of favoring arbitration as a method of dispute resolution. This is at the top of 540. However, in that case, instead of striking out totally the arbitration, what they did is they struck out that it had to be arbitrated by a particular person, and then they appointed somebody that was more neutral. So not only can they strike out provisions, they can modify them to make them fairer. At the bottom, right above Scott versus Cingular Wireless, they noted in business-to-business contracts, 2,800 contracts were examined by public firms with Securities and Exchange Commission by the way, there's a report you have to file if you're a publicly traded firm with Securities and Exchange Commission that gives financial disclosures. They apparently gave up the contracts, 2,800 of them, and they found that businesses don't like arbitration so much that only 11% of their contracts had arbitration in it. 89% did not, between businesses. Now, how many of those same businesses had arbitration provisions between the business and their customer?
Probably 100%.
Probably almost 100%, right? So it's, I want to do this in this circumstance, but I want to do something else in other circumstances.
That's hypocritical.
It is hypocritical. Just want to point that out to you. Now, Scott versus Cingular Wireless. First thing to notice before we call on somebody to brief the case is that the court sat en banc. Y'all see that term? You might want to highlight that term. En banc. B-A-N-C. Supreme Court of Washington en banc, 2007. Now, does anybody want to take a stab at what the Supreme Court of Washington en banc is?
Is that what they don't put their name on, like, no judge puts his name?
That's per curiam.
In
Close though. It's the entire court. Now, in Alabama, it's usually the entire court that makes a decision anyway. Apparently in Washington, a decision can be made by less than the entire court. In this case, they wanted to point out that the entire court made this decision. So en banc simply means the entire court. Okay, Ms. Lee.
Okay, plaintiffs purchased cellular telephones and calling plans from the defendant, which was Cingular Wireless. The standard pre-printed contract signed by the plaintiff contained a mandatory arbitration clause, which included a provision prohibiting class actions. Cingular's revised provision stated that Cingular would pay arbitration costs if the claim was not found to be frivolous, that it would reimburse the customer for reasonable attorney fees and expenses if the customer recovered at least the demand amount, and that if the waiver of the class action provision were to be found unenforceable, the clause for arbitration would become null and void. The plaintiffs commenced a class action in which they asserted that they were improperly billed for long distance and or roaming calls that resulted in the charges, and they were overbilled up to approximately $45 a month. The trial court disagreed with the plaintiff's contention that the class action waiver provision was substantively and procedurally unconscionable, and thereby were unenforceable, and granted Cingular's motion to compel individual arbitration, and the plaintiff's appeal.
Okay, so what happened on the appeal?
On the appeal, the court, there was a humble of the waiver. On the appeal, the trial court ordered granting the motion to compel arbitration, and it was reversed.
That's right. It was reversed. And they said that in quite a long opinion, I guess, start at 542, section B1 of the opinion. An agreement that has a tendency to be against the public good or to be injurious to the public violates public policy. That's actually a good statement of law, generally. And then an agreement that violates public policy may be void and unenforceable. That also is a good general rule of law. Now, where they got into their explanation was basically a state of Washington procedural issue. And I'll tell you that their procedure mimics the federal, because they still both rule 23 for class actions. They said that class actions exist because too many are injured to name. And that's really true. one of the requirements of class action is that you have to have numerous individuals that are injured, too numerous to be reasonably joined into the same case. Well, they just put it as too many to name. How many is too many to name? Tom?
I said that depends.
Well, it does depend.
Well, you only name one when you cite a case. So,
Yeah, you only name the first one when you cite the case, right?
so is it more than that?
All right, as far as having too many people to name and just end up calling it a class action, I've actually been on a case where they had 31 plaintiffs and 31 named defendants. So I can tell you that 62 people is not too many to name to keep it from being class action. 31 on one side of the V and 31 on the other side of the V. By the way, at least on the complaint, you have to list everybody, not just the first one on each side. Yes, ma'am.
So a lot of the homeowners association, they'll just like have multiple, even, you can get up to like 40, 50 something defendants. So you're saying in that instance,
There's over 100 in the homeowners association in my neighborhood. Go ahead.
so in that instance, you don't necessarily, like just say, because sometimes it's like the opposite, where it's like all of the people suing the homeowners, so you have all of these plaintiffs. So you don't have to necessarily turn it into a class action.
You don't. In the state of Washington, they just say it's too many to name. When you keep going, it says a realistic alternative to class action is not 17 million individual suits. That's on page 543. But 0 individual suits, as only a lunatic or a fanatic sues for $30. I thought that was just a funny quote. And how much were we fighting for on the refrigerator?
25.
No, the dating service. $300? 25 a month? $300 for the year? I mean, you can sue for $30. That's small claims. Yeah, it's 100.
Yeah.
So when they want to sue for $30, they say that that's a matter of principle. Is that right? When you go through this opinion, it says that it exculpates AT&T or Cingular, where at any time up to the end point they can just refund you your money and then you don't get any damages whatsoever. How does that protect the public? Well, it doesn't. It lets AT&T or Cingular out for each individual one. You just have to pay the one that complains. What you learn out of this is you call your cell phone company up and you complain. You complain that they dropped your rates to a lower plan. Call them up, they'll change your plan. They might even refund you a little bit of money. They're not going to do it for everybody. You got to take it up yourself. This is a bad holding in that AT&T Mobility versus Concepcion, starting on 546, has really thrown class action stuff into the wind. And there's a lot of uncertainty now as to whether or not waivers of class actions and class actions are available against companies as a whole. That's going to have to be litigated more before they can figure out the exact contours of what that law is. Just know that the Supreme Court recently has thrown that into a tailspin and the courts are still trying to figure it out. Probably the easiest thing for them to throw it out of is a state law ground called waiver. That appears at the top of page 549. Waiver is among the most common for traditional methods of avoidance. So the one last thing about a contract defense under state law is waiver. If you can show that the party waived it, well, if you waive it, it's raised, right? And if you fail to raise it, it's waived. Any questions about today's reading assignment? Next week we'll pick up at 550, starting at section 4. Now, is there anybody in here from last semester who did not take the exam? Ms. Collins? Rotondo? I'll have your exam. And Ms. Kafka? Kafka. All right, anybody else, you're welcome to stay, and we're going to go over these exams. If you weren't in here last semester and you want to just listen in, you're welcome to do that. Let's start with the essays. I'll call out your number and you can come up and get your essay. You do have to turn them back in. $62. $206.
Wait, I'm 0.
I know this is done on exam session.
Uh-huh.
No, that's not.
0206. That's your 235. I'm not calling out leading zeros. 517. 235 right here. 517. 553. 567. 67. When I call your number, let me know you're on your way up. 573, 582, 585, 590,
I'm on my way.
596, 90,
There's a second one behind mine.
564, 596, 598, 600, 606, 637, 641, 642,
Right here.
42,
Yes.
42.
Oh, you're
642.
I thought I was 42.
643.
Let me go look.
Okay,
and
did
see.
we?
I thought I was 642, but I may be wrong. Let me look my number.
Oh, folks, y'all got all your numbers.
I may be wrong. Go ahead.
Like, I've been putting 642 on here for what? You can have my other number.
Ms. Headington, you're 642. 643.
I don't know what.
644. 646. 44. 46.
You said 622?
644. 652. 654. 656. 662. Y'all know why the law school does this, right?
So we're anonymous.
Yeah, so it's anonymous. I don't know whose paper I'm grading when I'm grading it. 663. 665. Right here. 667. 670. $671.
71.
674. 677. 683.
643. I got off one.
83. 684. 694. 703. 84. 94. 703. 391. 453. 569. 573. 580. 583. 602. 604. 604. 619. 622. 625. 642. 649. 685. 687. 700. 700. Okay, folks, let's look at the essay answer.
What was the highest score?
19 out of 20. The highest score on this was 19 out of 20. There were 5 issues in here, 4 points each. One for the issue, one for the rule, one for the analysis, and one for the conclusion. If you did not get all 5 issues, you did not get all 20 points. You got 4 points for each issue that you did find. The first issue is whether there is a contract.
Did we write on this or?
No, please don't. Whether or not there was a contract, an oral or written one. The second issue is, if there was a contract, did the statute of frauds apply because it was over $500? The answer is yes, it did apply because it was over $500. The next issue was, did the statute of frauds apply because it was a signed paper? Was it signed? And is there any case law that says it doesn't have to be signed if the paperwork's generated by the one against whom it's sought to be enforced?
Really quick, I'm sorry, because it was like a month ago. Can you read the fact pattern you gave us?
Yeah, I'll do that right after this. The fourth issue was, is the statute of fraud satisfied because there was a confirmation letter? And then, did the statute of frauds apply as to 6 knives, but not all 10? So was the fact that there was a shipment for one amount, which was different than what they had agreed to, is the statute of fraud satisfied? And the answer is yes, if you accept a partial shipment and they say, here's your order of 6, then that is the statute of frauds being satisfied. So here's the fact pattern. On May 1st, a manufacturer and a chef met at a restaurant trade show. By the way, folks, this is an actual bar exam question. The manufacturer showed the chef some carving knives that were on sale for $100 each. After examining the knives, the chef said, I love these knives. I'll take 10 of them. Please send them to my restaurant within a month. As soon as I receive them, I will send you a check for $1,000. The manufacturer said, I'll be shipping the 10 knives to your restaurant in a few weeks. They said they'll be shipping it. And he took the chef's address for shipping purposes. On May 15th, the manufacturer sent 6 knives to the chef. Enclosed in the shipping box was a document on the manufacturer's letterhead that stated in its entirety, it is a pleasure to do business with you. Enclosed pursuant to our agreement are 6 knives. Please remit $600 at your earliest convenience. On May 17th, the chef sent the manufacturer a check for $600 and included in the envelope an unsigned note. You see where the signature's coming in? That's another one of the factors the statute of fraud requires. Unsigned note to the manufacturer, handwritten on plain paper, requesting the remaining 4 knives. The manufacturer did not respond to the note. The knives were particularly well suited for the chef's uses, and the $100 price was a bargain, so the chef was very eager for the manufacturer to deliver the remaining 4 knives. On June 17th, the chef wrote to the manufacturer claiming that the manufacturer was contractually bound to sell the chef 10 knives, and that the manufacturer had breached that contract by furnishing only 6 knives. The manufacturer did not reply to the chef's letter. Is there an enforceable contract against the manufacturer that binds him to sell 10 knives to the chef? Explain. Actually, I rephrased that and said identify and discuss all the issues that arise to the contract under this fact pattern. The actual bar question, is there an enforceable contract? That's too simple, but the actual bar question raises all 5 of the issues. So it's better to ask you identify all of the issues, and that doesn't mislead you into thinking there's only one. You have to identify all of them. So I thought it was a slightly ambiguous question. I fixed it. Identify all the issues. You're going to find questions like that says identify and discuss all the issues, and then you're going to find some of them that say answer this specific question. This one was misleading as to the 5 issues, so I fixed it. The 5 issues again were, number 1, is there a contract? Actually, there were 2. There was a written contract and an oral contract. The written one was for 6 knives, right? Because it was included in the shipment on a letterhead. That's a writing implied to have been signed because it was on the letterhead. Does the statute of frauds apply because it's over $500? Well, yes. It would apply for both circumstances. 10 knives for $1,000 with 6 for $600. Both of them are over $500. Is the statute of fraud satisfied because of a signature? Well, in the case of the letter sent on letterhead, it has been held that something sent on letterhead satisfies the signature requirement. And that is to be enforceable against the manufacturer because he drafted the letter, right? So the 6 knives that he said, pleasure doing business with you, here's your 6 knives, send $600, that can be enforced against the manufacturer because the writing is implied to be signed by the manufacturer. What about the oral contract for 10 knives? Number 1, it wasn't in writing, right? Number 2, was it signed by anybody? Was it over $500? It failed for all sorts of reasons, didn't it? Issue number 4, the confirmation letter. Confirmation letter satisfies the signature requirement, right? We had a case directly on point from the employer who hired the salesman and made a note on their letterhead in his personnel file. And then the statute of frauds as to the acceptance of the 6 knives. Was it enforceable? Yeah, but nobody was complaining about it, right? But it doesn't mean that it wasn't an issue, even though nobody was complaining about it. But the statute clause was applicable to the 6 because there was a writing implied to have been signed by one of the parties, and it was enforceable against them. And it was over $500. Now, that was probably the hardest hit that anybody took on this exam, was this question. Because you identified 1, maybe 2 issues. Very few people got 3 or more issues. And because we had 19 out of 20 points on this, there wasn't much of a curve either. Can't curve when somebody's already at the top. Any questions about the essay? Issue, rule, analysis, conclusions. There are the issues. The general rule is you have to satisfy the statute of frauds, you have to have a writing. Satisfy the statute of frauds, anything over 500 has to be in writing. Satisfy the statute of frauds, has to have a signature of the one against whom it sought to be imposed. And then statute of frauds satisfied as to the 6. Well, there was an acceptance of the 6. It's not a dispute, but it is enforceable to that amount. Not to the 10, but only as to the 6. Yes, ma'am.
Put statute of frauds all in one.
Well,
Address, $500, confirmed letter.
You remember our in-class assignment where we separated issues into separate paragraphs? Part of the requirement on this was to write it in a legal style where you put separate issues in separate paragraphs and you do IRAC in each paragraph.
Okay, so
Yes.
In the example that you did, you talked about condensing it as quick as possible. And like I have all 5 issues listed, but not separately in 5. I mean, all the things that you went over, all of them have been listed, but not in separate things. 30 minutes for 5 issues?
Yeah.
You're going to write an issue, you're going to IRAC all 5 things in 30 minutes?
Yeah.
That's 6 minutes.
Actually, when you get to the civil procedure, you'll find as many as 10 or 12 issues that you have to address in 30 minutes.
Professor
And IRAC every bit of those 5 different, like,
in your version, Professor Bodie.
Well, look at it from this. It's everybody's first semester, is it not? Are not every one of you in the same boat? The way that the law school actually dictates that the grades be done, and I'll explain this, all the first year classes you have to have 10 to 20%, only 10 to 20% of the class can get an A, 30 to 40% of the class can get a B, 20 to 30% a C, and 10 to 20% either a D or an F. I didn't have any Fs, I don't think. And I had too few Ds, even in the law school's curve. I think I graded too high for the law school to be happy with it, but whatever you got on the multi-choice and the essays together with the scale to put on the curve, however many points you got as against your classmates, that's exactly where the grade came in. There's the old saying that those who make A's in law school are going to teach law school, those who make B's are going to be judges, and those who make C's are going to be the ones that make the money. And that's the way that the law school sets out those grades to be. You're competing against your classmates to figure out where on this curve that you're going to land. And I tell you, I went back in and put pluses and minuses on the grades to let you know if you got a C plus, you were real close to getting a B. If you got a B minus, you just barely got past that hump to get above the C plus. When you get to studying for the bar exam, and you don't want to hear this, when you first start studying bar review for the bar exam, if you get 60% of the questions right, you're doing about average. 60%. To pass the bar exam, it's about 70% of the questions right to pass. But then the way that the National Conference of Bar Examiners does these is that they put them on a scale that adjusts for year-to-year variances. And so they have several years in which here's where you hit as a percentile of whatever your scores are. So it's not like undergrad or even some of your grad schools that you've been to where, you know, you do a certain amount of work and you get an A, or a certain amount of work and you get a B. The law school has a curve that it tells me to use. And based on how many points you get against your classmate is where it's got to fall on the curve. And, you know, they really hit within the numeric ranges. Surprisingly enough, it usually is about, you know, 10%, maybe 15% of the class, they get the A's because they scored that many points on the exam. Doesn't usually have to be much of a scale. That's why you don't scale at the midterm. You just wait for the scale to the finals. And I think it was less than 10 points total for a scale. So whatever you got is numerically close to where you got it. Yes, ma'am.
Have you considered throwing out the highest grade before you look at the curve?
I have, but when I look at the distribution of where these people would fall anyway, it doesn't change what the law school's curve is. That curve that they've come up with is from several years worth of grading all the first year students, and this is basically the distribution that they fall into.
Well, I'm talking about for your curve, because like on hearing someone got a 19. So you couldn't curve much because of that. If there's only one person scoring like that, that's what I'm saying. Have you considered throwing that out before you do your curve for the class?
I don't want my grade thrown out. I work
Well, not
hard.
thrown out.
Now, what you mean is actually thrown out is not being statistically significant.
Right, no, I know.
Because if it's just one, it sounds like it's just like one person scoring like this.
What I throw out is when I have an excessive number of people who miss a question. Like on the multiple choice questions, if I have 90% of people miss it, that's probably a bad question, and I'll throw the question out. But I don't throw out cumulative grades just because you know, somebody may work at a law office and know the answers. Work at a law office or work for a judge. They kind of are deemed to have an unfair advantage by some of their questions.
No, not true.
Oh yeah.
Not true.
You ask your classmates if somebody works at a law office whether or not they have an unfair advantage. Okay, that's the classmate saying that, right? But from a grading perspective, there's not an unfair advantage. The number of questions that you get right, yes, you may end up getting more questions right, but that's because you got the questions right, not because of where you work. I'll give you a prime example. Working in an attorney's office is usually a bad place, particularly in ethics. You need to have the theoretical how it's supposed to be done rather than the day-to-day how you see it done, and sometimes that gives you a disadvantage of here's how we've always done it at the office rather than according to a strict interpretation of the rules of professional conduct, here's how you're supposed to do it. And that's no kidding, folks. And that's not to say that whoever you're working for doesn't do it right. It's each one of those has to be examined case by case.
Can I ask a question?
Sure.
Formatting, and this, I completely didn't even use the right rules, so this doesn't bother me. I'm just thinking about what Mr. McCarthy asked. But if we have 5 issues to IRAC or 6 or whatever, in your explanation, 2 or 3 of them, the response or the issue was, does the statute of frauds apply? So whenever we first do our issue is whether statute of frauds is satisfied, and we explain statute of frauds. The next time we address that same issue relevant to 10(9) versus 6 or whatever, can't we just list the issue and analyze it, but not go through the point of defining it because we defined it above?
IRAC doesn't have a definition section.
Well, rule.
Well, it has a rule, but isn't the rule slightly different for a signature versus whether it's $500? I mean, statute of frauds.
Yeah.
The statute of frauds, in order to satisfy a statute of frauds, it has to be a writing if it's anything over $500. That's the rule for your $500 issue. To satisfy the statute of frauds, there must be a writing signed by a party against whom it sought to be enforced.
All right, but if we had listed it all at the top, because we just, go like that, then when we got to it the second time, could we say, as explained above, blah, 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 would that satisfy for purpose?
For your rule?
Would it just depend on how the writing?
It depends on how the writing spells it out.
I was just thinking in my head of ways to, cover all the IRAC of each issue without having to redo the rule every time if you've already stated part of the rule.
Well, and from the other side of it, if you start giving me an entire rule to explain what should be a limited, narrow issue, then you've not really responded to the issue you've identified by giving the whole rule. So if you say whether there is a contract, well, there is a contract. There's two of them. There's a written one for the 6 and there's an oral one for the 10. That answers the first, the analysis portion.
Just that little short part on that set.
Well, whether there's a contract can either be oral or written, as long as there's an agreement supported by consideration. In this case, there's two, one oral for 10, one written for 6. Therefore, there are two contracts.
Okay.
Then you get to the next one, whether or not statute of frauds is satisfied. Statute of frauds requires a writing for all contracts in excess of $500. Both contracts are in excess of $500. One's for $1,000, one's for $600. And is there a writing? Well, the answer is there is one on the $600, but there's not one on the $10. So the statute of frauds, because it's over $500, is only satisfied on one of the contracts. There's your conclusion. The next one is statute of frauds requires a writing signed by the person against whom it's to be enforced. In this case, where there's not a writing on the 10, no need to discuss it. However, on the 6, it is to be enforced, and since it was drafted on their letterhead, which is an implied signature, it can be enforced against the manufacturer. That's the conclusion. Now, is it an issue? No, because they already got their 6 knives. They're not complaining about those. But it's still an issue, even though it's not one that's going to support the lawsuit. See what I mean?
Yeah. Okay. Thank you.
I have the multiple choices here if we're done discussing the essays. Y'all go ahead and bring the essays up and I'll start handing out the multiple choice.
I'm not arguing.
Okay, 665. That's you? 533. 391. 654. 625. Y'all holler at your 625. 625. 652. 62. 62.
50, you said 52?
652.
62 right now?
62. 0062.
No, that's not me.
649. 646.
49, 649, 646.
662. No, these are random.
Did you say 660?
662. 573. 667. 602. 674. 590. 622. 622. 619.
Yes.
670. 567. 703. 600. 643.
Here.
564. 687. 604. 604. 582. 453. 453. 671. 642. 606. 656. 644. 644. 641. 553. 585. 700. 658. 637.
What'd you say? 677?
637.
Oh.
637. 583. Yep. 583. 206. 596. 684. 517. 580. 663. 685. 683. 677. 569. 569. 694. 235. 694. That's fine. 533. 391. 662. 670. 703. 600. 604. 453. 642. 606. 644.
Thank you. After they look at it,
656. 700. 6598. 0598. 643.
I just need to see what I mean.
583. 206.
That's me.
What's your
Right
number?
here. I'm sorry.
What's your number?
That's 612.
I just called it out.
You did, yes.
You don't want it?
I do.
Why didn't you?
684.
Thank you.
What's yours?
I think I wanted to give you this. You were talking about pro bono law.
Oh,
684.
okay, has everybody got one that wants to look at it? All right, questions?
I'm just curious to know what the class average
Yeah, I'm going about there.
Is anybody just interested in statistics? The average on the multiple choice was 54%.
The what?
The average was 54% on the multiple choice. The average on the essay was 23%.
What was the highest grade on the multiple choice?
$83?